the application may not be rejected and must be processed like all other applications. And so they filed a motion for a restraining order. Stop this. You're not allowed to accept these ballots. More than 60 people were standing in line. More were arriving at noon on Saturday when county officials came out and said they were cutting off the line at about 40 people, and some people won't make it inside. A federal judge in Pennsylvania is now saying that there is no requirement to check overseas ballots when they come in to match their number, to vet their social security number or their driver's license number, to check it. Doesn't even matter. If it doesn't match, that is not a justification for rejecting the ballot. That's not enough. So the numbers, in other words, don't matter at all. What are we talking about? We're in Pennsylvania, Middle District. We've talked about the lawsuit that was filed some time ago. This is an order from the federal courts, and it revolves around this directive change. You can see Pennsylvania Department of State published this some time ago, and they said, pursuant to our new orders, this is what we're going to be doing. The directive is now issued by the Department of State, the Secretary of State, to clarify and specify legal processes related to matching driver's license numbers and social security numbers for new voter registration applications. The directive underscores in bold, this is the rule, so if you're working in Pennsylvania government, this is what you're supposed to do now. The directive underscores that Pennsylvania and federal law are clear. That's their interpretation, so that's a big no, we don't know. We read it. They say voter registrations may not be rejected based solely on a non-match between the applicant's identifying numbers on their application and the comparison database numbers. So you send in a registration form, you say, my name is Robert Govea, my driver's license number is so and so and so whatever. Send that into them. They put it in, they look at it, numbers don't match. Oh, I can't know, so I should reject that. No, count it. They say all applications for new voter registration requires only the following: and a valid driver's license number, the last 4 digits of a social, or a statement indicating that they don't have either, okay? So you either need the numbers or you don't. And that voter registration, compare the information, that's all, compare. They say the comparison process was intended as an administrative safeguard for storing and managing the official list of registered voters. This requirement that you compare, it doesn't mean you're restricted at all. It doesn't mean check at all. It just means look at it. I guess just need to look at it. Oh yeah, they are different. Oh cool, totally fraudulent. Yeah, I compared them, totally fraudulent. Perfect, send that in. Counties must ensure their procedures comply with state and federal law, which means that if there are no independent grounds to reject a voter registration application other than a non-match, the application may not be rejected and must be processed like all other applications. It's important to remember that any application that's in pending status while a county is doing follow-up with an application of a number that could not be matched, you can see it right here, let me move my fat head out of the way, must be accepted unless the county has identified another reason to decline the application. So if the numbers don't match and you're following up, you must accept it. This is the rule that came out from Pennsylvania to all of their people. This is their directive. This is how you're going to process stuff when it comes in. Leaving an application in pending status due to a non-match is effectively the same as declining the application. So don't leave it pending. It's not pending. It's accepted. So accept the applicant as described. You cannot put it in pending. They must come in. So now we understand how it's working. So here is the order. The memo from the judge out of Pennsylvania federal court says the following. All right, now he's going to do this delay thing. You know, on September 30th, 36 days before the general election, Republican members of Pennsylvania's Congress, so these are state officials in Pennsylvania, sued Pennsylvania saying this is ridiculous. They're saying that they're not even checking numbers, saying that there is no legal compliance with verification of voter registration applicants' identity and eligibility. They just register you, they don't even check. And they're now granting the government's motion to dismiss, saying, yeah, that's fine, they're allowed to do that. So they're saying, we know all about the rules, UOCAVA, HAVA, and UMOVA. We've talked about these before, but there are all these different rules that interplay with one another. Here is what the challenge is about. The local Congress people were suing, saying that Pennsylvania law requires them to actually check IDs. They say that the Pennsylvania Department of State has issued a directive, the guidance that we just looked at, and his testimony saying that no, they're exempt from verification. He said during a hearing, the guy running this said they do not have to provide a driver's license number or ID, and they don't have to provide the last 4 of social. Says UOCAVA voters, these are the out-of-state voters who are not in the United States, they are exempted. Okay, so if you're out of state, you can register without an ID number and you'll get a ballot and you'll be registered, so your ballot will count. Just to be ultra clear about what's happening. This guy says, deputy secretary, they are exempted, so they don't have to provide ID. That's an exemption in federal law and state law. So there is no verification. Just sign up, get a ballot, and you can vote. Clear as day. He said it himself. Now, they believe that this practice creates an opportunity for the inclusion of ineligible ballots that might render the votes inaccurate, because UOCAVA applicants, the judge says, could theoretically register to vote, receive absentee ballots, including by email, which they get, and cast ballots without providing ID at any step in the process. In the worst case scenario, which is all true, in the worst case scenario, they submit that these lapses might leave federal elections vulnerable to foreign interference by falsified registrations, which might affect a close congressional election. And in this, they raise a single count, which they say is preemption. They're saying, oh, the question is, well, okay, so what do you guys want? Like, if all of that's happening, like, what do you want? Well, they want a declaration saying that their directive, that policy that we just read, violates the law. Stop the secretary from funding or facilitating this. They actually have to check, and they actually have to reject stuff. Require that they check their ID. And so they filed a motion for a restraining order. Stop this. You're not allowed to accept these ballots. By that date, by the time they already filed this, Pennsylvania had already transmitted 25,000 UOCAVA ballots to their intended recipients ahead of November 5th. See, that's a lot of ballots, man. As time was of the essence, we established an expedited schedule for motions practice. We permitted the DNC to come flying in here. We permitted the Pennsylvania Democratic Party to jump in. Bunch of people filed amicus briefs, and now they move to dismiss this case. So first, Latches and Purcell. We've talked about the Purcell principle, the idea that federal courts should not intervene in state elections in the final weeks and months before an election. And Latches, of course, is the idea that if you delay bringing a case and you shouldn't have delayed, then it's your problem. You can't bring it late. And Purcell. So you can see Latches and Purcell all happening here. He said, well, why didn't you guys bring this sooner? We asked why you haven't. The department issued its guidance 12 days later, and the individual plaintiffs provide no good excuse for waiting until barely a month before the election to bring the suit. When asked about this at oral arguments, why'd you guys wait so long? The state already made this change 2 years ago. They said, well, we just learned about the Iranians. Yeah, the Iranians might be sending in UOCAVA ballots or something. And we learned that there was an unsealed indictment against the Iranians back in September that raised concerns. And we thought, oh man, maybe the Iranians are going to take advantage of this. The indictment was talking about other matters, and you can't rely on phantom fears of foreign malfeasance to explain your delay in bringing this claim. So don't use the Iranians as an excuse. You guys should have brought this in place on your own. The disputed guidance, in which the department unambiguously declared its official position, it says overseas voters are exempt from the ID, was publicly available long before September 27th. That fact alone defeats the plaintiff's alternative suggestion that their delay was due to the failure to give public notice. And so you just waited too long. Now, the relief you desire is also a non-starter. You want an order directing the county boards to segregate the ballots for potential exclusion 3 weeks into this litigation, and interveners who represent Democrats overseas would also be threatened. Many people would have to expend vital resources, and it's just way too late in the game. Plaintiff's remedy would hamstring election administrators less than 2 weeks out, and that's why we have Latches and Purcell. And so we will grant the motion to dismiss on that basis. Latches, extreme prejudice would result if you were allowed to wait so late into the game and then bring your claim. They also talk about standing. They say these congressional plaintiffs don't even have standing. As for the organizational plaintiff, the group does not identify a single member who has even been injured. Vote dilution is wholly speculative, inadequate as well. And so the foregoing tenets apply with equal force here. We cannot stop the secretary from doing anything that's going to affect the overseas ballots. More than 25,000 of those have already gone out. The secretary has no authority to direct the counties to segregate those ballots. And so your prayer for relief is not going to happen. They must now live with that decision. You guys waited too long to sue. And for these reasons, they're going to grant the motion to dismiss, and those votes are going to come in. They don't even have to check the numbers, and there's 25,000 of them that have gone out already. So signed in conclusion by Christopher Connor, saying plaintiffs delayed too long to file their action. They lack standing. They failed to join the indispensable parties. They failed to articulate a viable cause of action. And so they're going to grant the secretary's motion to dismiss. They're going to deny as moot the motion for a temporary restraining order and an injunction. And that is how Pennsylvania will go. Meanwhile, we've also got some other Pennsylvania congresspeople who are upset about what's happening in Pennsylvania. You see a bunch of these people, these folks who are local congresspeople, Brian Fitzpatrick, Frank Ferry, and others in Pennsylvania sent this letter in to the Board of Commissioners saying, we've got some election problems in Pennsylvania happening happening now, saying, hey, commissioners, you know, the right to vote in our representative democracy is one of the most sacred rights. It's the responsibility of our election officials to make sure things work. One can argue there's no greater threat than voter disenfranchisement. And as elected officials, we are deeply troubled by recent reports and widespread constituent concerns over the past 24 hours involving Bucks County voters who are looking to cast their ballots this past Saturday. According to news reports, more than 60 people were standing in line. More were arriving at noon on Saturday when county officials came out and said they were cutting off the line at about 40 people, and some people won't make it inside. Our office has fielded complaints from constituents, which include voters attempting to enter the Board of Elections line prior to the 2 p.m. deadline, and voters claiming that county officials are impeding them from exercising their right to vote. Many constituents now fear they will not have the opportunity to vote this year. While there is no question that on-demand, in-person mail-in voting is a courtesy provided by and carried out by our government, this incident has sent shockwaves throughout our community and is causing individuals to lose faith in our system. This potential disenfranchisement of voters must be rectified so that every eligible voter is able to vote. As you're aware, last week, the Pennsylvania Secretary of State Al Schmidt sent an email about the absentee deadlines. In his email, he said 5 p.m. was the deadline to request absentee ballots. He asked every county official to review their plans, and he said they should go on to consider other changes. Now, while we understand the process of this, mail-in ballots are not specifically outlined in the law. And as elected officials, we ask that the recommendations from Schmidt receive full and fair consideration and provide us with this information. There's no denying we're in the midst of a truly historic election cycle. We're going to have one of the highest voter turnouts in American history. We're a few days away from the election, so thanks for taking the time to look into making these changes. Please listen to this person and follow his recommendations so that these people are not disenfranchised. Signed by a bunch of people in Pennsylvania. So interesting. Now, we had something sort of similar happen in 2022 with Kerry Lake here in Arizona. People showed up to go vote and they couldn't go vote. We saw how that election went, and now we're stuck with Katie Hobbs. So we're going to keep our close eye on stuff like this and other election interference as it unfolds. Thanks for subscribing as we do.